something to Michael Jackson's finger after the fact, which occurred to me, and maybe we can go to Dan Conaway on that. To me, that struck me, and I'm not a medical doctor, obviously, but if the person is already presumably quite possibly dead, and you're starting to attach monitoring equipment, that little device that goes on the finger, which he put on Michael Jackson's finger way down the road, what does that tell you?
It shows consciousness of guilt. It shows covering up a crime scene. And, you know, he is a doctor. Okay, he's not an anesthesiologist. Okay, he's not a cardiologist, but he's still a doctor. And the fact that he doesn't do these things until much later, and he's dealing with covering up evidence first, and then the lengthy time before 911 is called, all really paints this picture, quite frankly, at least for today's testimony, I think much more damning for Dr. Murray than a lot of people maybe thought at the beginning of this trial. It looks terrible. This looks like someone who is more concerned for their own skin than for their patient.
So, Ted Rowlands, you're in that courtroom. You're talking about what the defense is doing on cross-examination. That continues after the lunch break.
You're a former prosecutor, Dan Conaway. Is this something that the prosecution sits down every couple of days and says, hey, we're doing good. Let's go offer them a plea deal, perhaps, and end this early?
It happens all the time, but I think that the defense lawyer made a great point in this, and that is that if you have a client that says over and over again, I'm not guilty, and then as the defense lawyer, you lay out the facts of the case, and you say, look, here is the evidence against you. This is going to be really tough. But despite the logic of the argument, your client insists, I am innocent, I did not do this. You can't have him take a plea, in fact, because then there are exceptions. There is an exception in the law called the Alford plea. You could do an Alford plea, but I don't think as the prosecution is going to offer an Alford plea in this case. Ultimately, Conrad Murray would have to step up and say, I am guilty of what I am charged. And he's obviously not doing that, and so therefore his defense team is doing their job. The other option is trial, and so here we are.
And you know, Mike Galanos, I'm thinking there may be another angle here, which is, let's say there was a plea, let's say for some miraculous reason they said no jail time. He's still got a medical practice. Remember, he's got 7 children, he's got family. He probably wants to keep that medical practice going as well.
Well, I've heard that from an expert saying that that's why he went to trial, was to save that license, as opposed to just taking a plea and may have never gotten that license back. One thing I want to throw out there, guys, before we go to break is propofol in the IV bag. We were led to believe by the defense that it was a finite injection from Dr. Murray. If you put propofol in that bag, what's this jury thinking? Are they thinking the defense has lied to us already? Half of them Michael Jackson fans? Think of that.
You know what? We're all confused about the defense contention, but in confusion there can be reasonable doubt. Stay with us.